Judge Elias Vance looked down from his high bench, not at the defendant, Faraz al-Jamil, but the silent, veiled girl sitting 2 rows back, Layla. He'd sworn an oath to justice, yet the words that left his lips weren't law, but a chilling, open mockery of her faith, accusing her father of being part of a backward tradition that poisons American soil. Subscribe call. Smash that subscribe button and ring the bell. Don't miss the moment this girl's quiet faith became the loudest defense in court. Join the channel and support real stories of complex justice. But let's go back to where it all began. The air in the courtroom of the Southern District of New York was thick with the silent, suffocating weight of political theater, not jurisprudence. Faraz al-Jamil, a man whose life had been dedicated to running the largest Muslim youth center in Queens, sat at the defense table, his shoulders visibly slumping beneath the absurd charge of providing material support to a foreign entity. The core of the prosecution's case was nothing but a collection of selectively edited emails and anonymous, classified intelligence reports, the kind of evidence that the defense couldn't even fully examine, a chilling example of the post-9/11 justice system weaponized against the community. Layla, 17, was the only family member allowed in the front rows, her presence a silent act of defiance against the palpable hostility in the room. Her plain black abaya and tightly secured hijab made her a focal point, a visible other in a gallery dominated by sharp suits and government agents. She was not just Faraz's daughter. She was, to the media and the court's inner circle, an emblem of the very culture the prosecution was painting as inherently suspect. Layla clutched a worn copy of Federal Rules of Evidence tucked in her handbag, the paper edges softened from endless nights of study after her regular schoolwork. No one saw her, really. They saw the stereotype, the silent, obedient, perhaps oppressed Muslim girl, dragged unwillingly into her patriarchal family's troubles. During a brief recess on the third day of the motion hearings, Faraz's court-appointed attorney, a weary man named Mr. Henderson, approached Layla with tired eyes, a clear signal of defeat already etched on his face. "Your father's assets are frozen, Layla. We're fighting with one hand tied behind our backs. The judge, Vance, he's not even pretending to be impartial. He keeps pushing that cultural motive narrative. The jury pool is tainted before they even walk in." Layla nodded slowly. "He's doing more than pushing, Mr. Henderson. He's ruling based on it. Did you notice he struck every single one of Mrs. Khan's expert witnesses on Muslim philanthropy? He called it irrelevant cultural window dressing." Later that afternoon, the defense motion to suppress the classified intelligence that was the actual backbone of the case failed, predictably. Layla had predicted the citation Vance would use, a highly criticized appeals court ruling that broadly interpreted reasonable suspicion in cases involving groups labeled as potential foreign threats. As Judge Vance dismissed the motion with a cold, almost bored finality, Layla could no longer contain the tremor of anger mixed with fear. She leaned forward, the creak of the old wooden bench loud in the sudden silence. "Your Honor." Her voice was clear, low, and sharp, a surprising intrusion into the decorum. Vance stopped mid-sentence, his gaze finally snapping to her. "Yes, young lady. Do you have business before this court?" Layla met his eyes. "The Fifth Circuit ruling you just cited in U.S. v. Haddaf. It was overturned sub silentio by the Supreme Court's denial of certiorari in Khadija v. DHS last quarter. The implied lack of due process in the FISA warrant interpretation is no longer valid case law for this jurisdiction." A stunned silence fell. Even Mr. Henderson's jaw dropped. Layla, her face impassive, remained standing. She hadn't yelled. She hadn't cried. She had deployed a rare, obscure legal phrase, sub silentio, to imply the quiet, unstated dismantling of his legal precedent. Judge Vance, a man accustomed to the complete submission of everyone in his court, especially the families of his targets, felt the blood rush to his neck. His face darkened, not just from being challenged, but from being challenged by her. He straightened his robe, his voice dripping with condescension that transcended mere judicial authority and sliced directly into her identity. "Miss Al-Jamil, that's what it is, isn't it? The veiled spectator. Perhaps you should stick to your cultural pursuits and allow the men to discuss the law. This is a court of American justice, child, not some uneducated attempt at a community defense. You are a passive appendage in this matter, and your opinions are noted and dismissed. The explicit, unmasked dismissal of her legal knowledge, her agency, and her presence, all rooted in the visible symbol of her faith, was the shocking moment. It wasn't just what he said, but the cold, public way he used her identity to justify the systemic bias of his court. Layla simply bowed her head slightly, her outward calm hiding the seismic shift of determination that had just occurred. She walked out of the courtroom not as a defendant's daughter, but as a silent, formidable opponent. His words had gifted her a clarity no legal textbook ever could. This wasn't about the law. It was about power and prejudice. And she knew exactly how to use the real law to break both. The insult Judge Vance hurled, passive appendage, uneducated attempt at a community defense, had the intended effect of silencing the gallery, but for Layla, it was a volatile catalyst. She walked out of the courthouse, the granite steps cold beneath her feet, not retreating, but calculating. His prejudice was now a confirmed variable, a fixed point in her equation of justice. She no longer had to navigate a neutral system. She had to expose a hostile one. Her father, Faraz, a man whose charity work had inadvertently attracted the scrutiny of a government paranoid about Islamic outreach, was facing a decade in a federal prison based on a foundation of legal quicksand. Layla knew that Mr. Henderson, the appointed lawyer, was operating under the assumption that a fair legal process existed. He was wrong. The system had already chosen its narrative. A successful Muslim community leader must be hiding something, and the daughter, the quiet girl in the hijab, was merely a cultural prop. That night, the only light in Layla's apartment came from the laptop screen, illuminating the dense, labyrinthine text of the Patriot Act's amendments on surveillance and the obscure procedural rules of the Foreign Intelligence Surveillance Act, FISA, courts. Her father's case hinged on the admissibility of a single, cryptic transcript detailing a wiretap conversation, a piece of evidence obtained under a FISA warrant that Layla suspected was issued without the required due diligence, based purely on racial profiling dressed up as national security intelligence. The government was hiding the warrant itself behind the shield of national security, but Layla found a crack in that shield. She focused on the procedural review of de minimis violations, minor technical errors in the warrant's application that, cumulatively, could render the entire surveillance operation inadmissible, especially when the case's central theme was clearly motivated by religious and ethnic bias. It was a long shot, a legal maneuver so granular that only a specialist would notice it, let alone dare to attempt it. The following morning, during the routine pretrial motions, Layla sought out her father's lead attorney, Mr. Henderson, in the cramped, stale hallway outside the courtroom. She presented him with a meticulously organized folder. "Mr. Henderson, I found the fatal flaw. It's in the FISA renewal application, specifically the minimization procedures disclosure. They failed to demonstrate that the surveillance was limited to agents of a foreign power, as defined in Title 50, not just individuals communicating about charitable donations to a region the State Department has flagged." Layla pointed to a specific, almost microscopic footnote in a 20-year-old Supreme Court dissent. The government has repeatedly used a broad-stroke definition of foreign power that this dissent, which has since been cited in 2 key circuit opinions, deemed unconstitutionally vague. If you connect this with their failure to document the minimization logs, we have a clear Fourth Amendment violation. Mr. Henderson stared at the teenage girl, then at the folder, the weight of his own career visibly pressing down on him. He had seen this kind of hyper-detailed, fanatical dedication before, usually from law school valedictorians, not high school students who looked like they were attending a religious study group. But Layla's analysis was terrifyingly precise. He recognized the citations. They were solid, but dangerous. "Layla, this is too much. You are asking us to challenge the very foundation of the intelligence used in these cases. If we file a motion to compel the minimization logs, we'll be challenging the national security apparatus itself. We risk provoking the judge. You saw how he reacted yesterday. He'll bury us. We need to focus on reasonable doubt, on the money trail, on Faraz's good character. We can't afford to be seen as fighting the war on terror itself. We'll be labeled a terrorist, sympathizer defense." His fear was a tangible thing, a weary surrender to the political reality of defending a Muslim client in this climate. He was afraid of being associated with the very stigma that was crushing Layla's father. "No, Mr. Henderson," Layla countered, her voice low and steady. "That is precisely the point. The charge against my father isn't about the money. It's about the narrative of the suspect faith. If we don't challenge the method of the profiling, the bias is legalized. We have to make the court justify how they got the evidence in the first place, or they will keep using fear to bypass the law. If we fail here, every single Muslim charitable organization and community leader is next. This isn't just about Firas al-Jamil. It's about the weaponization of fear against a minority. You must file the motion to compel discovery of minimization logs before the day is out." Henderson hesitated, sweat forming on his brow. The professional risk was immense. But the unwavering certainty in Layla's eyes, the sheer, ferocious intelligence radiating from the quiet girl he had dismissed just 24 hours earlier, shook him. He glanced at the folder, then at the clock. "I can't risk it, Layla. It's professional suicide. I'll prepare a standard motion in limine, but I cannot and will not touch the FISA logs. The risk is too high." Layla didn't argue. She simply took her folder back, the movement deliberate and final. "Understood, Mr. Henderson." She had offered the key to a legal defense, and he had flinched. The realization hit her with the cold clarity of steel. If the established system was too afraid to fight, she had to fight the system herself. She left the hallway, her resolve hardening with every step. She had been insulted, dismissed, and now abandoned by her own defense. Judge Vance had called her a passive appendage, but he had severely misjudged the power of a mind armed with law and fueled by righteous indignation. The defense wouldn't file the motion. She would find a way to make the information public, forcing the court's hand. She knew the rules. She had to find the obscure procedural exception that allowed a pro-SE, self-representing, action from an involved party, even one officially barred from participating. The trial proper was set to begin next week. Layla had 7 days to crack the code of the American judicial fortress. Layla spent the next 4 days in the unforgiving glare of her bedroom lamp, the air thick with the smell of stale coffee and the cold certainty of her isolation. Henderson had not only refused to file the motion to compel the FISA logs, he had become colder, distancing himself, clearly spooked by the risk Layla represented. His professional fear had given Judge Vance the exact leverage he needed, a defense team too intimidated to challenge the premise of the prosecution's entire case. That Firas al-Jamil was a covert threat and his organization a conduit for radicalism. Layla knew that without the discovery of those internal minimization logs, the mandatory documentation proving the government filtered out irrelevant, non-threatening conversations, the jury would only see a politically charged narrative built on fear, not facts. The government was counting on the sheer complexity of national security law to bury the truth. But Layla had found a hairline crack in the fortress. It wasn't in the core legislation, but in the arcane procedural rules governing emergency judicial review of warrants. Rule 41G of the Federal Rules of Criminal Procedure typically dealt with motions for the return of property. However, an obscure, often ignored footnote added in a 1989 amendment offered an exception. A third party with a direct, personal interest in property that was illegally seized and was essential to their defense could petition the court for its immediate return or inspection, even if they were not the defendant. The property in question wasn't cash or equipment. It was the digital files containing the surveillance logs and the initial, unredacted FISA application itself. The documents that would reveal whether the warrant was a legitimate intelligence gathering or a racially motivated fishing expedition. Layla was a third party with a direct interest. She was next in line to run her father's organization, and the government's action against him paralyzed its charitable work, her property. It was a legal Hail Mary, relying on the judge's own hubris. The motion had to be filed under her name, Layla al-Jamil, citing herself pro-SE, without legal counsel, and referencing the nearly forgotten footnote. By doing so, she was forcing Judge Vance to publicly acknowledge her participation, the passive appendage he had dismissed. She typed out the motion late on Sunday night, her fingers flying over the keyboard, citing the appellate cases that had used Rule 41G in non-traditional discovery contexts. The language was cold, dispassionate, and devastatingly precise, stripped entirely of emotion, focusing only on the legal mechanism of the Fourth Amendment violation and the specific procedural failure to document minimization. She knew the moment she filed it, she'd be painting a target on her own back. On Monday morning, Layla dressed carefully, choosing a slate gray hijab that contrasted starkly with her black attire. She walked into the courthouse, not to the main clerk's office, but to the discreet counter for Pro-SE filings. She handed the thick, meticulously bound document, motion for return of seized property and compelled discovery, to the clerk, her hand steady. Within the hour, the document was delivered to Judge Vance's chambers. The reaction was immediate and seismic. By lunchtime, Mr. Henderson cornered Layla in the hallway, his face white with fury and panic. "What the hell is this, Layla? You filed a motion. You and Pro-SE. Do you have any idea the professional trouble you've put me in? The judge is spitting nails. He called me. He called you a back-alley legal activist and threatened to hold you in contempt for procedural abuse." Henderson hissed, his voice trembling. "This is not how American justice works, Layla. You don't challenge the intelligence apparatus with a footnote. You just guaranteed your father a conviction and yourself a restraining order from the courthouse." Layla stood her ground, her gaze unblinking. "With respect, Mr. Henderson, what you were doing guaranteed my father a conviction, only with less dignity. You were too afraid to use the law that was available. I am not. And if Judge Vance wants to hold me in contempt, he will have to do it in open court, and he will have to rule on my motion first. I cited 5 precedents. He cannot simply ignore it without a written denial. He is trapped, Mr. Henderson. He has to either reveal the logs or reveal his bias by contorting the law to block a legitimate filing by a 17-year-old girl." She turned her back on her father's lawyer, leaving him trembling in the hallway. The trap was set. Now, she just had to wait for Judge Vance to decide how he would try to claw his way out of it. The stage was now hers. The quiet, veiled girl had just forced a corrupt federal judge to play her procedural game. The morning of the procedural hearing on Layla's motion was charged with a tension far greater than the start of any criminal trial. Layla arrived early, taking her place in the gallery, her Pro-SE motion, a legal grenade tossed into the heart of the prosecution, resting on the court's docket. Judge Vance entered the courtroom not with his usual weary formality, but with an almost predatory focus, his eyes immediately sweeping the gallery until they locked onto Layla. He seemed to want to incinerate her with his gaze. The prosecution team, led by a tight-lipped, ambitious prosecutor named Ms. Davies, exchanged nervous glances. They had anticipated fighting Faras's aging lawyer, not his teenage daughter armed with an obscure footnote. Judge Vance did not waste time. "The court is in receipt of a highly irregular filing." His voice boomed, sharp and laced with disdain. "A motion filed by a third party, Miss Layla Al-Jamil, styled as a motion for return of seized property." Miss Al-Jamil approached the lectern. Layla rose and walked to the defense podium, her back straight. Her father, Faras, watched her from the defense table, his face a complex mix of terror and profound pride. When she reached the podium, the judge stared down at her, the condescension of his previous remarks magnified by the formality of the setting. "Miss Al-Jamil," Vance sneered, emphasizing the formality of her full name, "I remind you that this court explicitly advised you to adhere to cultural pursuits and let the law be handled by professionals. This filing is a transparent attempt at procedural abuse, wasting the court's time and resources. I could hold you in contempt of court immediately. Your filing references a defunct rule and attempts to relitigate a matter already settled. Do you have anything to say before I strike this entire filing from the record and order you to pay sanctions?" Layla adjusted the microphone, her voice quiet but carrying perfectly through the speakers, a stunning contrast to the judge's booming anger. "Your Honor, respectfully, I request that the court address my motion on its merits, not my identity. My filing cites the 1989 amendment to Rule 41G, specifically the Kramer dissent, which was adopted in principle by the Ninth Circuit in 2017, a precedent relevant to this district on questions of unlawful seizure of financial data impacting a third party's operations." She spoke the legal jargon not as a regurgitation, but with the calm authority of a scholar. The property is the electronic discovery that confirms the targeting of my father's organization through illegal, non-minimized FISA surveillance. The motion compels the court to either release the surveillance logs or rule that the seizure of the data was based solely on racial and religious profiling, which is itself unconstitutional, nullifying the primary evidence. Ms. Davies, the prosecutor, leaped to her feet. Objection, Your Honor. The defense is arguing pure conjecture. This filing is irrelevant and attempts to challenge classified intelligence. It is a fishing expedition designed to distract from the defendant's guilt. The defense did not file this motion. Ms. Davies, Layla interjected smoothly, turning to the prosecutor with a sharp, professional glare. I filed this. And if it is a fishing expedition, then the government should have no fear of releasing the minimization logs. Their refusal confirms their fear that the warrant was obtained under false pretenses, targeting the faith rather than a crime. Judge Vance slammed his gavel down. That is enough, Miss Al-Jamil. I find your continued legal theorizing bordering on subversive. You are challenging the integrity of the federal judiciary and the intelligence community based on a single, convoluted footnote. He leaned forward, his voice a dangerous hiss. I asked you to explain your attempt at abuse. I will not tolerate this ghetto defense tactic. He stopped himself, catching the wrong word just a fraction too late, the true nature of his contempt slipping out. He quickly corrected it, but the damage was done. I mean, this community defense tactic to derail this trial. The slip was audible. Layla didn't flinch. She seized the moment, her gaze unwavering as she looked directly at the court reporter, ensuring her next words were on the record. Your Honor, the integrity of the court is challenged only when it allows institutional bias to dictate the law. My motion is about the Fourth Amendment. But your language, first calling me a passive appendage, and now attempting to brand my defense as a ghetto defense tactic, even quickly correcting it to community defense, demonstrates the very prejudice that necessitates the inspection of these logs. You have shown the court that you presume guilt based on our faith and ethnicity. By refusing to apply the letter of the law in Rule 41G, you confirm that the government's evidence is tainted by your own Islamophobia. I'm not asking for sympathy, Your Honor. I am demanding the rule of law. The courtroom was absolutely silent. Layla hadn't just used the law. She had used the judge's own poisonous words against him, forcing the central issue of bias into the formal record. The judge was cornered. To strike the motion, he would be formally endorsing the prejudice Layla had so clearly articulated. To grant it, he would be cracking open the secretive world of FISA surveillance and exposing his close working relationship with the prosecution. His hands trembled on the bench. He saw a 17-year-old girl, an emblem of the very people he had judged, using his own system to expose his corruption. He had underestimated the power of true legal conviction when it was backed by the moral clarity of the oppressed. Judge Vance's face was a mask of incandescent rage, trapped between the political risk of granting Layla's motion and the career-ending fallout of having his openly prejudiced remarks on the record. He had been forced to confront the systemic bias he embodied, not by an ACLU lawyer, but by the veiled spectator he had scorned. He struck the gavel again, less a symbol of order and more a desperate cry for control. The court will take a 15-minute recess to consider the procedural validity of the motion. Layla returned to her seat next to her father, who reached out and squeezed her hand under the table, tears brimming in his eyes. You should not have done that, Habibdi. Now he will crush us both. Layla leaned in. He has been crushing us since the day you were arrested, Baba. Now he has to do it on the record, with the whole world watching. She knew the risk. She just had to pray the power of the law outweighed the power of his corruption. When the court reconvened, the tension was suffocating. Judge Vance began reading his ruling, his voice clipped and strained. He used convoluted legal phrasing to tear down Layla's pro-SE attempt, calling the Kramer precedent wholly inapplicable, dismissing her legal argument as a desperate and unwarranted reading of procedural rules, and concluding with a definitive, chilling declaration. The motion is denied. Furthermore, Miss Al-Jamil is hereby barred from attending any further proceedings in this case, and the court will consider sanctions against the defense counsel for encouraging such an egregious abuse of process. Victory for the judge. Utter, complete defeat for Layla. As Vance prepared to move to the next item, Ms. Davies, the prosecutor, began gathering her papers with a smug smile. Layla, however, did not move. She waited until the courtroom was shifting, the moment when attention was lowest, and she rose again, without permission. The judge looked up, livid. "Miss Al-Jamil, I just ordered you to." Layla cut him off, her voice suddenly loud, echoing with a fierce, controlled certainty that shook the courtroom to its core. "Your Honor, I accept your ruling on the 41G motion. But before I leave, I must inform the court of another procedural failing, one that you cannot simply deny." She reached in her bag, pulling out not a legal document, but a small, plain manila envelope. "This is not a motion, Your Honor. This is evidence." She walked past the defense table, ignoring the shouts of the bailiff, and placed the envelope directly on the court reporter's desk, ensuring it was logged. "Your Honor, in preparation for my motion, I obtained public records on the court's recent expenditure on technology, specifically the contract for your chamber's private network upgrade." She paused, letting the implication hang. "My father's case relies heavily on the testimony of a single anonymous informant, whom the prosecution claims exists solely within the classified FISA evidence. However, your denial of my motion forced me to look elsewhere." Layla then turned to face the entire courtroom. "I found a non-classified, unsealed vendor invoice filed in the public city records last week. The invoice, which is now on the record, is for the installation of an encrypted voice-over IP system in Judge Vance's private chambers. The date of installation is listed as 3 days after the initial FISA warrant was granted in my father's case. The vendor, SecureCom, is a company known for providing pretrial coordination systems to the Department of Justice." A collective gasp swept through the gallery. Layla pressed her advantage, her voice a weapon of pure truth. "This invoice is significant, Your Honor, because I also found an email, not classified, obtained through a simple FOIA request, from Prosecutor Ms. Davies to the SecureCom technician, complaining that the new encrypted line was not properly masked for internal review and was inadvertently logging calls. This log I obtained legally, under public records law." She looked directly at Judge Vance. "The log, Your Honor, shows a private, non-recorded call from Ms. Davies' personal cell phone to your chamber's new encrypted line, 1 hour before you denied the defense's habeas corpus motion last month. The topic of the call, as briefly logged by the system metadata, Al-Jamil informant cover story verification. The prosecutor, Ms. Davies, had gone ashen, scrambling for her notes. Judge Vance's face was no longer red with anger, but deathly pale, his career and freedom dissolving in the heat of Layla's discovery. She had not only cracked the institutional bias, she had exposed a direct, illegal collusion between the presiding judge and the prosecution, coordinating the fabrication of an informant's existence to justify the surveillance. Layla finished, her voice a low, ringing indictment. "You did not want to release the FISA logs because you were not afraid of the law. You were afraid of the truth. There is no legitimate, anonymous informant, Your Honor. The entire case is predicated on manufactured evidence and judicial corruption. And I demand, on the basis of judicial misconduct and obstruction of justice, that this trial be declared a mistrial, and that a formal investigation of your conduct and Ms. Davies' conduct begins immediately." The courtroom erupted. Bailiffs rushed to the judge, who was struggling to maintain his composure. Ms. Davies could be seen whispering frantically into her phone. Layla stood motionless at the center of the storm, the quiet, veiled girl who had been called a passive appendage. She had used the system's own administrative oversight, a petty equipment invoice, and a log complaint to expose the deep, ugly rot of institutionalized Islamophobia that had nearly destroyed her father. Her quiet act of legal defiance became the very movement for justice the city and the community needed.